The matter, my lord. My name is Mutiso. I do alongside my senior, Danstan Omari.
I'm present, Your Honor.
My lord, the matter is coming up for pre-trial. The court attention two matters. One is that we have not been served with the statements or the documents which the prosecution intends to rely on this particular matter. Further, we wish to address the fact that my client informed me that two of his gadgets, one a mobile phone of the make of Samsung A23, and a laptop of the make of HP, were confiscated, yet he did not sign the itinerary form. Further, I wish to bring to the court's attention our client was arrested from Eldoret. He is currently being presented in Nairobi. There is an issue in regards to jurisdiction. Our client travels all the way from Eldoret to appear before you, my lord. And the final trivial issue, of which I do believe it is, I may be jumping the gun because I don't have the particulars of the statements the prosecution intends to rely, is on the issue of the charge sheet in itself. On quick perusal of the charge sheet, you'll note that the offense which has been cited there, which is under section 22, subsection 1 of the Computer Misuse and Cybercrimes Act, make reference to publish. The concern that we do have as the defense is the fact that we do not have the president listed as a witness in this particular matter. It is our view that all these things, the IO ought to be someone to give us a considerable answer onto why we do not have inventory on those particular items. Two, on the issue of jurisdiction, why our client was being arrested in Eldoret and being forced to appear in Nairobi. And three, whether there is an existing witness statement from the president on this matter.
Malaika, Your Honor, I've been instructed in this matter to come on pro bono to bring to the attention of this court that this is a university student. Of Moi University student. The state has dragged him here. He's in fourth year. You know, Your Honor, I didn't go through 844. Now they call it 4.2. Ours, we went through the 3-year course. He's a student at Moi University in fourth year. And it's public knowledge that Moi University is on a deathbed. Students are stressed. They don't know whether they'll ever finish their schools, their university. The young man publishes us a caricature on X. The state drags him here. I intend to write to the Director of Public Prosecution to review the decision they made to charge this young man. And also to review the policy on whether political dissent by citizens and their right to criticize their leaders, one being His Excellency the President of the Republic of Kenya, the criminal justice system can be used. You know, in the famous Gachagua matter, the judiciary took a position that political matters need to be dealt with politically or through ADR. This young man needs not to be before you, and that's why we are writing to the DPP. Number two, the Law Society of Kenya that has been representing this young man has asked whether the President, His Excellency, will take the dog to prove whether he is alive and he is not the one who was in that casket. That will be a national embarrassment. Because we shall be demanding that he comes to testify whether he was or he was not. Your Honor, for the benefit of the DPP, this is the third matter I've handled of a similar nature. The first one, where the voice of His Excellency, retired President Uhuru Kenyatta, somebody mimicked his voice, and they managed to swindle a prince in Dubai a lot of money. We demanded the President to come, and the state had to withdraw that matter. The second one was the same President Uhuru Kenyatta and Raila Odinga walking at night during COVID time. And we demanded they come to court. The state withdrew that matter. Based on those two, I urge the state to listen to me very clearly that this is a matter to be terminated. And that is why they cannot provide statements a mere post of a coffin is not what the state should be concerned about with these young people, the Gen Z people. We should be concerned about other matters. Your Honor, it is my humble prayer that you give us time. We approach the good office of the Director of Public Prosecution to review and withdraw these charges. It does not harm anybody. Lastly, Your Honor, also to bring to the attention of my good prosecutor is another charge. We saw on social media somebody being charged that he had shouted, "Ruto must go." And the court declined that charge and said, there is no charge, criminal charge sheet to that effect. Your Honor, it is my humble prayer. I've addressed you, but I've addressed my good sister there to tell their bosses, let Kenyans enjoy their freedom of creativity and talking. Let the office of the Director of Public Prosecution stand firm and stop the DCI from embarrassing the office of the Director of Public Prosecution. May the court grant the orders the Law Society of Kenya has asked. And Your Honor, when you see the Law Society of Kenya leading the defense, that is a matter of great national interest. And the DPP should see that this is not an ordinary matter, that the Law Society of Kenya, 21,000 advocates representing this young man. That is the implication. That's all, Your Honor.
It has been put to you that we have not supplied. It's not that we have not supplied, we are yet to supply. That is the very reason we were coming before you for trial. To respond to the issue of the trial before I respond to the application, there are reports that we are waiting for. We'll be seeking a further mention so that we can supply the entire bundle together. And this bundle consists of also the statements that the defense, I do not yet have the benefit of knowing who the witnesses are. So as that's now, they are preempting the statement. Whether it's there or not there, they shall not appoint them, they are supplied their documents. The charge sheet is not always the full indicator of all the witnesses. It can hint at some, but does not give the entire list of witnesses. To the issue of also the inventory, that should form part of it's preempted, it's part of the supply. Yes, we do have it. They was actually, they were submitted to forensic analysis. That is the report we are waiting for. As to the issue of a review of the decision to charge, part of the duties of the DPP is to prosecute as well as review cases. So they are at liberty to approach our office.
Yes.
However, let it be noted that this was not brought out of political malice. The DPP was discharging his duty as per the constitutional mandate. We have an open door policy. They can come, they can write to the DPP, the application is considered. But let us not jump the gun. We can still approach our office. Lastly, yes, to the issue of jurisdiction, this is not the first matter we've had where maybe the offense has taken place in another place, but it has been brought to the money. Because that decision sometimes is made due to public interest. As stated by the defense, that LSK has taken the first hand to present the defense because this is a matter of national interest. Now that is also the same consideration the DPP makes in deciding sometimes let us bring the case to the heart to Milimani where most of the matters of public interest are heard. So, we will supply them, we're just seeking for time. You can have them probably in the meantime. Seeing there has been a bit of delay with the side of the forensic lab due to reasons beyond the offices, infrastructural reasons.
Inventory form. When an arrested person to the police station and evidence is being confiscated, the person ought to sign off on that particular inventory form. The purpose of signing off on the inventory form is to accommodate on the issue on the chain of custody of evidence. The submission for the prosecutor in that instance means that any evidence that will be brought here from is going to be inadmissible. Therefore, our request still stands for those particular gadgets to be surrendered to our client. Further, on the issue of jurisdiction, there is nowhere in law that states that where a matter of public interest overrides matters of jurisdiction. As a matter of fact, any PO raised on jurisdiction takes precedent before any other matters are actually adjudicated upon. Therefore, it is very vital for the IO to be summoned here and tell us exactly why the quote-unquote public interest overrides the matter of jurisdiction. Essentially, courts will dismiss matters for want of jurisdiction. Finally, I'll just support the sentiments of my senior counsel, Danstan. We will approach the office of the DPP as we wait to be submitted with this other particular document. But in that essence, the prosecutor does not have to wait for the forensic reports. We can be submitted with these other statements. Therefore, I'm willing to actually even facilitate for those particular documents to be brought to my office today.
Intimated that let him write to the DPP, because I'm sure it's an ongoing process of reviewing. So I think that will be my direction, and I'll urge parties to do so. Obviously, discovery and supply of statements is an ongoing process, but I'll urge whatever they have, they should supply to you, counsel. Yeah? So we'll take a date to confirm the same, as also we await the DPP direction on whether he would still wish to pursue or otherwise. So we can take a date maybe in January, late January. And then on the issue of jurisdiction territorial, we'll also address that once we get the intimation whether the DPP intends to proceed or otherwise. So let's first of all deal with the issue of the DPP, because if he discontinues, there's no point of referring this matter back to maybe Eldoret, where maybe the accused resides, or schools. So I think let's address that first issue. Once we surmount that, then we can address the issue of the territorial jurisdiction. I believe that is in order. Okay, so we can agree on a further date for pre-trial. So I didn't want to comment whether the president is a witness or not, because let's wait and see from the statements, yeah? And then we can give directions on that. So which date? Is it convenient?
Yes, it is convenient.
Alright, so pre-trials on the 28th of January. Okay, thank you. Okay. Nani hajasikia kesi yake? Anyone? Yes, please. Which one?